Hey guys, this is John Watts. I'm a foreclosure defense lawyer in Alabama. And I want to follow up on the last video I did about sort of these individuals, maybe through a company or a trust, but basically individuals buying old second mortgages. And then they show up and maybe you haven't made a payment in 5 years, maybe it's been discharged for 5 years in bankruptcy, and they show up. And I thought it might be good to give you some examples. So some of this comes from cases we've had. Some of this comes from as I read their blogs, as I listen to these guys on podcasts and just hear them talking. And it's very interesting, but mainly these are from actual cases we've had where the owner, let's say it's, Susie, the CPA in New York City, and she's bought your second mortgage. It's a $50,000 second mortgage, and she paid $10,000 for it. You haven't paid on it in many years. And so she'll say to herself, you know what? I want to go ahead and get the money flowing back in on that. So she writes you a letter. It says, hey, I now own this, and you've got to start paying. If you don't pay, I'm going to foreclose on you in 30 days. Oh my goodness, what is this? Well, is that legal for her to do that? Well, let's look at your mortgage. A typical mortgage will say that before they can foreclose, they have to do certain steps. So step number one is send you a notice of default letter. It says, hey, you're in default. You have made payments for 1,000 days or whatever. Here's how much you owe, and you better pay this to fix or cure the default. Here's your deadline, at least 30 days from now. And then if you don't do that, we're going to accelerate your loan, so it's all due, and we'll foreclose on you. Well, in my example, she didn't do that. She just said, you start paying or I'm going to foreclose on you in 30 days. No, she's got to do that notice of default letter. Well, maybe in the mortgage it says any notices have to be sent by certified mail. So she doesn't send it by certified mail. Or she hires a servicing company to do this. But they're not real familiar. Or they're just used to the typical mortgage does not require it to be by certified mail, but yours does. And so they just don't send stuff by certified mail. Well, it's not valid. That's the position I take because they did not comply with the mortgage. And so did they do that right? Well, other people will say, you don't need 30 days. I'm going to give you 10 days. And that's being generous. Well, if the mortgage says 30 and you only give me 10, then you violated the mortgage. Well, sometimes they'll say, you know what? I'm going to threaten you. If you don't start making payments, I'm going to start notifying your neighbors that you're going to be foreclosed and you're a deadbeat and you're not paying the bill. So you better pay or I'm going to do that. And these people will think they can do this and there's no consequences. But there are just amazingly bad consequences for them when they do this sort of stuff because they can be sued. And they say, well, I paid $10,000 for this second, mortgage, this second note. I want my money. It may be, hey, buddy, you don't get any money, and you're going to pay money, and you're going to be thankful that you pay money, and you give up this note, and you leave Alabama and don't come back if you're not going to follow the rules. So there are all sorts of federal laws. There are state laws that apply. And so when these people just say, well, I'm going to skip these steps, okay? Or maybe you have a loan that's been discharged in bankruptcy, and people buy discharged debt because that lien is still there. Okay, you don't owe the money, but that mortgage is still tied to the property. Okay, and so under the right circumstances, they can foreclose even on a discharged debt. But what they'll do is they'll write you and they'll say, you need to start paying this. Well, they got to be really, really careful how they word that because there's a discharge order that basically, like if this is you and this is the debt, it's like there's this wall between you and the debt and nobody can bring the two of you together. Okay, that debt can't cross that wall, that discharge order, and get to you and say, you have to pay this. But these guys will just say, I don't care about a bankruptcy. You're still living in the house. You better pay the debt. Well, they may have just violated the bankruptcy order. They may have violated the Fair Debt Collection Practices Act. So there are all sorts of things that these guys do. So here's just a general rule when you're dealing with any company, but particularly if this is an old second mortgage and we're just seeing more and more of this come about. document very, very carefully. So you get a letter from them. Save that letter. Save the envelope. Scan it in. Get on your phone. Get a scanning app if you need to. I mean, you can take a picture of it, but it's better if you have a scanning app because it'll put it in PDF format. But take a picture of the envelope and the letter. I mean, we've had even big companies that we've sued before, and there are really strict deadlines involved. And so the letter will be dated May 15th. Okay? And they go, you got 30 days from the day of this letter to do something. But we look at the postmark. It's postmarked June 10th. Wait a minute, I just got it like June 13th. So that's not fair. And when we sue them for this, they go, well, I mean, all that matters is when we print the letter. Even if we leave it on our desk for 3 weeks, that doesn't matter. Like, I want to see you argue that in front of a federal jury. That would be fun to see you argue that. Of course, they never do because it's a stupid argument. Save the envelope. Save the letter. Read the letter carefully. Whatever the letter says, then pull out your mortgage. Compare it. Okay? Are these things matching? Sometimes these guys, when they buy these old mortgages, and they're buying the debt, which is the note, and they buy the mortgage, which ties the debt to the dirt. Sometimes they don't have an actual copy of the mortgage. It's just a spreadsheet, and so they don't know what it says, and they're just guessing. And apparently they're too lazy to go look in the probate court because that's where your mortgage is. And so what they say in the letter may not match what's in your mortgage. Well, that can be very good for you, very bad for them. So just be aware of this. Sometimes we'll see these guys, it's really foolish, but they'll start credit reporting on you. This is a debt you haven't paid since 2010. It's way too late to credit report on you, but they'll start credit report, or they'll threaten to credit report. They'll say, we're giving you 30 days to get caught up, and if you don't get caught up, we're going to start credit reporting on you. Really, really bad mistake. Okay? So there's all different ways that they can violate the law, but if I could leave you with this thought, document very carefully what they do, compare it to what your mortgage says, and compare it to what the law says. And if you don't know what the law is, get with a lawyer that does this type of work so that they can sit down and help you understand, okay, here's the letter, here's the mortgage, here's the law. How do these things compare? And it might be that, you know what, you need to work with these people. You need to try to resolve the situation. You need to pay them off, whatever it is. It may be, don't pay these jokers a dime because they have so botched this foreclosure, this acceleration, this notice of default, that you're not going to pay them any money. They're going to be paying you money. So that's my suggestion for you, my advice to you. If you live in Alabama and have any questions, my name is John Watts. You can reach me at 205-879-2447 or alabamaconsumer.com. Thanks for watching this video, and I'll catch you in the next one.